Is it on now? Okay. Brenna, you think my vision is better than what it is. For everyone who's down here, if you're going to be down here, you need to put on your mask. That's required by the courts. All right, everyone, please be seated. Hear me? Is there's anyone who cannot hear me at the back of the room? Please raise your hand and let me know. All right, as you can see, everybody is wearing a mask. We're all required to wear a mask in the central jury room. And my goal is to make sure that everyone is protected. So anyone who ends up on this jury will be in the 187 District Court. And in the 187 District Court, as here, I make sure that everything is sanitized and everyone is protected. My name is Stephanie Boyd. I'm judge of the 187 District Court. You're here for jury selection. I'm going to have the state introduce themselves to you. State.
Hunter Morris. Good morning, Joe Ray Garcia.
And for the defense.
Ron Zimmerman for the defense.
And your client, please.
Mr. Michael Hernandez.
All right, as I said before, you're here for jury selection. The parties who were just introduced to you, is there anyone here who recognizes or knows any of the parties that were just introduced to you? If you do know any of the parties, I'm going to ask that you please raise your hand. Does everyone have a card? So let's practice. Could everyone raise your card? Awesome. So anytime there's a question that's asked and you want to be recognized, what we're going to have to do is I'm going to need you to raise your card, and then the party who's asking a question, they may follow up with you. Now, I mentioned that this is a jury trial. So there are certain rights that everyone who's charged with an offense has. One of those rights is the right not to testify. So what that means is anyone who's accused of a crime has the right not to give testimony, has the right not to be called as a witness. Is there anyone here who will hold it against Mr. Hernandez if he decides not to testify? The other right that everyone has is they have a right to decide who will decide punishment in their case. In the state of Texas, you have what's called two phases of a trial. The first phase of the trial is to decide whether someone is guilty or not guilty. If a jury or if a judge would determine that someone is guilty, then they would go to the next phase of the trial. That phase of the trial is called punishment phase. You do not get to the punishment phase unless someone is found guilty. In Texas, a defendant or anyone who's accused of an offense and goes to jury trial, they must decide before jury selection that if they were found guilty, who they would like to decide punishment. They can either decide to go to the court, which would be the judge for punishment, or the jury. In no way does this selection state or mean that a defendant or an accused is guilty. It's just that the laws of Texas requires everyone who's in a jury trial to make that decision. In this case, Mr. Hernandez has decided if he were found guilty, he would want the court, that would be me, to decide punishment. Is there anyone here who will hold it against Mr. Hernandez that he has decided to come to the court for punishment if he were found guilty? All right, the next thing I want to talk to you about is burden of proof. In Texas and in other states, the state must prove their case beyond a reasonable doubt. A person who's accused of a crime does not have to prove anything. The burden of proof for the state is proof beyond a reasonable doubt. When I graduated from law school in 1997, there was a definition for proof beyond a reasonable doubt. I knew the definition backwards and forwards. You had to state it. The law has changed. There is no longer any definition for proof beyond a reasonable doubt. The one witness rule. The state may talk to you about a one witness rules. This is the rule. If the state were to present to you only one witness, and I want everyone to listen to this fact scenario very carefully. If the state were to present one witness and you believe that that witness is credible, and you believe that with that one witness, the state has proven its case beyond a reasonable doubt, then the question is whether or not that is enough for you in your mind to find somebody guilty. And there's a lot of confusion about the one witness rule. The key to the one witness rule is you must believe that the witness is credible, and that witness must have given you evidence or presented evidence to prove each and every element that the state has to prove beyond a reasonable doubt to prove their case. Does everyone understand? So here's the hypothetical that the state usually gives. If the state were to bring only one witness, you believe that witness, you find that witness to be credible. That witness proves the state's case beyond a reasonable doubt as to each and every element. Is there anyone here who will say, that's not enough for me, I still want more? If there is, raise your hand or your card. Right. The next issue, time constraints. I'm sorry, is someone raising their hand or their card? What is your number?
24.
Number 24. 34. 24. Yes, that's what I said. 34. 35. 48. 38. number 60. And 67. 29, are you raising your card?
I'm thinking about it, but no.
Oh, you're not raising yours? Okay, all right. Time constraints. This is not California. This is not a trial that will last, 6 months or 3 months. However, you all who are selected for this jury will be called back tomorrow to hear testimony. Is there anyone who has a time constraint? Now, what do I mean by time to screen? Sorry, this mask is playing havoc with me. What do I mean by time constraints? You're leaving the state. You have a non-refundable ticket. You're leaving tomorrow. Is there anyone who has that type of time constraint? And that is number 47 and 24. And number 33. All right. Now, what Mr. Hernandez is charged with is theft under $2,500 enhanced. Is there anyone, and I want everyone to think about that charge, is there anyone who feels like this is the type of case you would not be a good juror for? All right, number 10. And before everyone raise your hand with that answer, it's a theft enhanced under 2,500. So is there anyone who feels like there is something about the fact that it is a theft enhanced case under 2,500? And I know I have my mask on, and when I say theft, T-H-E-F-T, is there anyone who feels I can't sit on a case because it's a theft case?
I have a question. What do you mean by theft by hands?
No, enhanced.
Oh, yeah, okay.
Yes, no problem. It's the mask. Okay, is there anyone who feels like this is the type of case you wouldn't be able to sit on?
What is it?
The state will discuss that with you.
Oh,
Okay? If you want to speak, okay, number 80, you're raising your hand? All right, so that's number 80. All right, before I turn it over to the state and the defense to ask you questions, I'm going to tell you a story. It's a true story. When you're in law school, you make friends, and they're friends for a lifetime. And all of us went into different fields. I went into criminal law because criminal law has always been my passion. I always knew this is what I wanted to do. Some of my friends decided to go into civil law. And a majority of the civil attorneys are not in trial a lot. So my friend got selected to come down for jury duty. She says, Stephanie, let's do lunch because I have jury duty. I'm like, great, because we speak on the phone, but we haven't seen each other because usually, sometimes with the civil firms, you're working 80 hours a week. So she comes down and we meet for lunch. And I ask her, how is jury duty coming along? Are you liking it? She's like, it's great, but I'm not going to get selected. And I said, why are you not getting selected? And she's like, oh, it's like law school. I'm on the back row. I'm keeping my head down. I'm not saying anything. And I started laughing hysterically. And she says, why are you laughing? And I said, because for some reason, the way it works in jury selection is people who do not speak end up on the jury panel. So other than raising your card and begging the state or the defense to select you, the major way to be on a jury is by not speaking. So I say that to let you know you need to be engaged, listen to the questions from the state and listen to the questions from the defense. None of these questions will be designed to embarrass anyone. So keep that in mind. All of your answers are the correct answers. And with that, I'm going to turn it over to the state.
Thank you, Judge, Counsel. Hey, folks, I'm Hunter. I work with the DA's office here. And as Judge explained, this is called jury selection. If jury selection, then you have guilt, innocence, and then it's calls for punishment. And what we're really trying to do during this part of the trial is to figure out who's going to be the best juror for this case. Because Mr. Hernandez has rights, and the state has the right to bring the case. We want to make sure that you'll take the case seriously, but be fair to Mr. Hernandez. So that's really the point of this whole thing. I'm going to go through the law a little bit, like Judge said, and then give you some hypotheticals to make sure that everybody understands what the charge is and what it looks like when it plays out in trial. And we want to figure out if anybody has any bias, and not just biases like, oh yes, my house was burgled last night. I don't think I can sit on the step case because I'm very angry about it. But maybe biases from a cultural thing from growing up, maybe a friend you had growing up that was known for having sticky hands. Maybe you're a big fan of Home Alone, and you really like the sticky hands, things like that that maybe aren't at the front of your mind, but could affect your ability to be fair and effective. So that's really what we're going to be going through today. I'm not here to judge you. It may feel like that a little bit because of the questions that we have to ask, and depending on the answers, maybe some harder questions. But I'm not judging you for your answers. I'm just trying to understand better. This is a theft enhanced system. What does that mean? A theft enhanced? It means that we are alleging that there have been 2 prior convictions for theft. So it is an allegation that there is a theft that has occurred on this particular date, and prior to this particular date, the same person has 2 convictions for theft. So that is what a theft enhanced is, and I'll go through the elements with you here shortly. But first, as an example, can y'all see the PowerPoint okay? It's on these 2 big screens. Does anybody know who these folks are? What did Cheech and Chong like to do? Burn a little Brittany? Do you think Cheech and Chong would be good jurors on a marijuana case? I mean, in fairness, those cases are disappearing. But would they be fair on a marijuana case if we had marijuana case? Probably not. I have another example for you. These 2 guys. We're just talking about them. Do you think they'd be good jurors for this case? Probably. Probably not. So, personal example. This didn't actually happen, but if it did. If somebody were to burgle my car on the way in this morning, I parked in the garage and it's so busy, nobody's paying attention, everyone's in a hurry, but it gets burgled. And I'm coming in for jury selection. Would I be a good juror in that case? Probably not. Maybe I don't know who did it, and maybe nothing was taken, they just broke in and tried to find stuff. I'm heated, you know, a little worked up about it, I'm anxious. I have a hard time focusing, I have a hard time thinking when this is serious, whatever the case is. Maybe a little worked up. Do you think that'd be fair? Probably not. And it might not be because I'm biased. It could just be because I couldn't fairly give attention to the evidence, which also would not be fair. So let us know if that applies to any of you. Anybody here, just based on this hypos, feel like, you know what, this is not the case. And it's okay if that is, but we need to know. We have jurors number 4. Juror number 10, and I'll come back around to that side. Please keep them up. Juror 52, juror 74, juror 38, 26, 29, 24, 48, 77, 78. And thank y'all for holding up your cards. There's a court reporter here that's trying to take everything down. It's difficult enough being spread out like we are. So if you have an answer, please do go up to the microphone, or a question or an answer. Please go up to the microphone if you call on you, and then please do raise your flag. The mask makes it even more difficult to understand what's being said if you can't see lips. I'm going to try to be articulate. If you can't understand what I'm saying, please let me know. The benefit of it, you can't see my phone. Your card, please.
I have a question.
Yes, sir.
A favor. Can you put your microphone a little bit to your mouth? I have a little hard hearing on my left ear, so sometimes I can't hear you very.
So juror 16 asked I hold the mic a little closer. I will do that. Thank you, juror 16. All right, so that's under 2,500 in hand. Elements. We need a date in Bear County, Texas. The defendant, the accused person, without consent, unlawfully appropriates property with intent to deprive the owner, and in this case, has been previously convicted of theft 2 or more times. The judge mentioned a little bit to you the burden of proof in a criminal case. And as she also explained, there's no definition, although there once was. And so some people can find that kind of confusing and nebulous. So let me give you an example. Let's say you have some family in town that's not normally here. They're really excited about seeing the Alamo. They don't pay attention to the local news, so they really want to go hang out at the Alamo at night. We kind of go in the evening. It's kind of clear outside, nice weather-ish. But when you get out of the Alamo, all of a sudden, the street's wet, the sidewalk's wet, the plants are wet, the doors are wet, everything's wet. You got some people out there with no problems. What happened outside while you were in the Alamo? Juror number 8. Juror number 8? It rained. It rained. How do you know it rained? Water on the street. Umbrella. She says water on the street, there's umbrella. So there are certain things about what you're seeing that tell you it rained. Is that correct? Correct. But you didn't see it rain. Correct. So common sense, beyond a reasonable doubt. In your mind, you'd be convinced at that point that it rained. Okay. That's really what we ask for in the end is common sense. And it is our duty to prove it. Unfortunately, there's not some clear, bright line definition for you. When you are considering the elements, it's important to remember that just because there is a question, there may not be a doubt. Just because there's a doubt doesn't mean it's reasonable. So I could say, you know what, folks? I actually heard that a prop plane that was supposed to fly over Lago, Texas accidentally got moved into downtown San Antonio. They were rerouted based on some emergency. They had a landing strip out of Congress, and the water fell out of the plane over the Alamo. You probably think that's crazy. You're right, that would be crazy. Could it happen? Maybe. Is it reasonable? Anybody think that's reasonable? All right. So again, this theft appropriates property unlawfully without the consent of the owner, 2 or more prior convictions. What is appropriate is to exercise control or possession over something. That's it. I am exercising control over this clicker. It's not actually my clicker, but I'm exercising control over it. So at this point, I would consider that. The definitions for that be kind of confusing. I'll keep it simple. Exercising control over something.
Slow down.
I'm going to slow down. Does anybody have any questions about appropriate? What that means? Exercise control or possession. It's just a fancy word for moving, taking. Unlawful. When is it unlawful? Anybody have any ideas when it's unlawful to take something?
I can't hear you.
Chair number 17, can you step up to the mic?
And when everyone steps up to the mic, please do not touch the microphone.
When you take it without permission.
Without permission. Chair number 17. The law likes to confuse that and call it consent, but yes, when you take it without permission, it is unlawful. So if you appropriate something unlawfully, putting it together, you're using, taking, manipulating something without permission. Does that make sense to everyone? Anybody have any questions about that? Okay. Does anybody think that big companies can be victims of crime? Yeah. Does anybody think they cannot? Is anybody sitting out here thinking like, listen, legally I can see that being the case, but I don't actually believe these companies can be victims? Anybody feel that way? They own property too sometimes. Okay. When we say intentionally is when it is someone's conscious objective to achieve a desired result. So the theft statute requires an intent. You intentionally train, intentionally appropriate unlawfully. Change the slide. Anybody have any questions about that? That basis can be kind of unique. I won't confuse you too much. But technically, as soon as you intend to take something permanently, Without consent, of course, without consent. So let's say at Hastings, remember Hastings? It's a small town, Texas thing. Anyway, they used to rent movies and rent videos, video games and music and stuff. I'm at Hastings and I said, you know what? I'm gonna take this Backstreet Boys out. And I'm not gonna pay. And I pick it up, but maybe like 10 steps down the way, I'm like 12 years old, I'm afraid. I said, you know what? No way, I'm not taking this. Technically, at the moment I picked it up saying, I'm taking this. That was theft. But again, I backtracked a little bit. So we need evidence to kind of support that mentality because these defendants aren't microchipped, to my knowledge, so we can't read their minds. What kinds of things would you as a jury look for to say, oh yeah, they meant to take? Anybody have any ideas? Like if you're looking at evidence for potential theft case, what are you looking for to say, oh yeah, they meant to take that? Juror number 21.
Like damage to a jewel case or something.
Okay, damage to a jewel case.
Literally like break something to try to take it.
Okay, all right. Thank you, juror number 21. Juror number 24.
Conceal it. Like hit it.
Okay, but the mic,
Oh, Mike, please. Thank you.
So concealing, if they hid it in a way to try to conceal it from detection that they were taking it, or, you know, hide the fact that they were taking it.
Okay, concealment. Thank you, juror number 24. Juror number 33, if you could please step up to the mic.
They have no remorse for taking it.
No rewards, okay, thank you. Juror number 34.
Possibly behavior, his actions.
What do you mean by behavior? If somebody takes something they don't have permission to take, where are they going?
Where are they going? They have intent. They show some action and that make me feel like they're doing something that they shouldn't
I
be.
got you. Do you
So
think it's
intent.
typical for them to hang around once they take something, or do you think they're gonna take off?
Well, it depends. Either way, I've seen it, they might hang around a little bit just to cruise out a little later, make
Okay.
sure no one's watching, and cruise out.
Okay.
So behaviors,
Eyeball
the
movement.
actions, yes, sir.
All right, thank you. Anybody else? Juror number 76? You good. Thank you.
Avoiding eye contact.
Oh, if you
Good
could
night.
step up to the mic, please. Thank you.
Avoiding eye contact or any sort of like range of people, keeping their distance.
Okay. All right, so suspicious behavior. Thank you all. Anybody else? Sorry, it was a little. So the statute, this particular statute addresses repeat behavior. So what that means is that an element of the offense that we in the state have to prove to you is that this suspect has been convicted 2 times before theft. So my question to you, because we also want you to be fair to Mr. Hernandez, is if you see that evidence, we need you to still be impartial and assess the evidence on the current accusation. So the charge of the particular date needs to be independently proven. Does that make sense? Is there anybody here that would see 2 prior convictions and automatically be more likely to find her guilty? All right, let me explain this a little bit more. So these are all accusations, right? The state, we have brought a charging instrument as indictment against this defendant, and we are alleging he committed an offense from this date, and we are alleging that he is previously convicted of 2 prior dates.
And I'm sorry, just one moment. All of the fact scenarios that the state is giving, those are just hypotheticals. They are not about Mr. Hernandez. So all of this is hypothetical.
Correct. Hypothetically, we would be accusing the suspect of having 2 prior thefts. And the law requires the jury to be impartial and assess the evidence for the current accusation, not allowing those 2 priors to affect whether or not it happened this time. You can't say, oh, it's happened before, it happened again. The law doesn't let you do that. And if you feel like you would do that, it's important that we know. But knowing that the law says it has to be independently proven beyond reasonable doubt that it happened this time, does anybody feel like they would not be able to shake knowing that there are 2 prior allegations?
Wait, I have a question.
Yes.
So
Jury
are you
number
saying,
62.
are you saying that the two prior allegations haven't been proven yet?
So,
Or that's hypothetical?
the elements of the offense require us to prove before the jury deliberates, give you evidence to support a finding that the jury could believe beyond a reasonable doubt that they have. That's a really long-winded way of saying we have to still prove to the jury that those two prior convictions exist. So we're not starting trial with the assumption that there are prior convictions. We have to prove that. That's something we have to prove. Does that explain it a little bit to folks? We are alleging that they haven't, but we still have to prove that to you. Okay.
So why, I guess I'm confused about why you would tell us about the two prior
Jury number 3.
trees. Why tell us about the two prior if it's not even, how does it do with this current case?
So that's a good question. And some laws in Texas don't let you talk about that because of this concern. But some laws like this one require it for what's called jurisdictional purposes. Because it's an enhanced degree and it puts it in a felony court, it makes it an element of this offense. And so it's something that is discussed in the legal innocence phase. So I need to figure out now who's going to be fair. Hope that explains your question. Jury number 21.
So in basic terms, what you're saying is that each instance of theft has to be proven independently from each other. And that the prior instances of theft, even after proven, the one currently being being proven also has to be independent of judgment from those.
Right, so the new case has to be proven independently, and the two prior convictions have to be proven also. Right, so we're not, there wouldn't be 3 different thefts trying to be proven up. There'd be one theft, current theft, and then at least 2 prior convictions. Jury number 41.
Yeah, I think I'm just still trying to wrap my head around proving a prior conviction. Isn't that a matter of public record? Like, what is there to prove at this point?
Well, unfortunately, I'm bound by rules of ethics, so I have to, we have to follow certain rules and guidelines for trials, but occasionally, yes, some documents are certified public records, and there are different rules that apply. Jury number 75.
So was the initial question, you're asking us basically if we can be impartial, right? If he had 2 prior convictions. Was that what you were asking?
That's ultimately what I need. to know.
That's what I thought you were
Yeah.
asking. Yeah, that's what I thought you were
That
asking.
is ultimately what I need to know. Can you? Your number, what's your number?
75,
Can you be fair and impartial, number 75?
definitely. Yes.
Does anybody need any more explanation on that?
Okay, yes. Yes, please. All right, everyone, just give me one moment and I'm going to pause you for a second. Yes. Yes. Okay, let me. I do. Hi, you could probably see better than I can, right? Awesome. Maybe if we move it forward. Hunter, if you could help her pull that forward, please.
Oh,
Okay, that's good. Yes. All right, and I paused your time so you can continue. Sure,
may I proceed?
yes.
Thank you, Judge. Thank you, folks. And I'll pick it up. I understand it's being kind of long-winded. So what kind of evidence would you expect to see in a test case? Keep in mind that since CSI, we don't have the unlimited resources of Hollywood, but what kinds of things would you hope to see in a case? The state forum with that? With evidence. Anybody? Turn to Ray.
Police report?
Police report, glad you brought that up. So police reports cannot actually be admitted to evidence. But it can be used occasionally to refresh memory. I'm glad you brought that up. Thanks. Turn number 7.
Video?
Video. Sometimes there's video. Turn number 58.
Recovered, stolen merchandise?
Recovered merchandise. Okay, thank you. Turn number 66.
Fingerprints?
Fingerprints. You know, we would be so fortunate if we had the resources and their kind of a fingerprint on theft and hand cases. I haven't heard of that happening yet, but hypothetically, I suppose that is something that would be helpful. Turn number 29.
Confession. They confessed.
Oh,
They were
confession.
approached and they confessed. And that's what happened to me last week.
I didn't hear.
Okay.
Have her repeat that at the mic.
Can you repeat that at the mic, please?
Confession. And once you are, that person was approached and confronted, and that's what happened to me last week. So,
And I don't know anything about that experience yet. Would you like to come back and tell us about it individually or?
now, right now?
or do you
Probably
believe-
individually.
do you believe that you could be fair and impartial?
No.
Okay, we can come back and talk about it then. We're gonna move along. So Judge mentioned briefly the one witness rule. So in Texas, what that means is that if the state brings you a single witness that proves each element beyond a reasonable doubt, and you believe that witness has proven each element beyond a reasonable doubt, whether you would be able to find the defendant guilty. The state allows that. You can and shall find the defendant guilty if you believe beyond a reasonable doubt that every element has proven, and that can be done with just one. Is there anybody here knowing that even believing the testimony of one witness, you have to reason doubt? So you still need to- Okay. So I'll just repeat it so we don't get anything too confused. So following this hypothetical, no changing of the rules in this hypothetical. The hypothetical is you hear one witness from the state, you believe that witness, and you believe that that witness has proven every element of the offense beyond a reasonable doubt. Can you find the defendant guilty, or would you need more still? Even though you believe this witness beyond a reasonable doubt, there's no doubt, no reasonable doubt in your mind that this didn't happen. Who would still need more? Even though the law is not. Turn number 4. Turn number 13. Turn number 22. Turn number 4. Turn number 31. 42. 38. 37. 34. 46. 48. 60. 66. 50. 61. 7. Are you going to do that? Did I get you? That is not true. Thank you. Okay. 67. Did I miss one back there behind the pillar? Oh man, 67. Thank you.
Does that pertain to that scenario that you had up there, though?
This question right here.
The question that you just asked, is it pertaining to that example?
Oh, this is just a hypothetical, but I was just telling you without a hypothetical.
So,
Would it be helpful if I gave you one?
well, if that was a hypothetical, then I would also.
If the prior hypothetical is also, okay, I'll just put you.
That was the scenario of your question. I would need more.
You would need more. Okay.
Because basically what you're saying is that you have only one person telling you that this person, and without reasonable doubt, but yeah, I'm good.
Okay.
I still need more.
Sorry.
Sorry.
Number 12, you look like you were kind of,
Same thing as them.
okay.
All right, excuse me, just 1 second. I'm gonna pause it for a moment. Here's the hypothetical, everyone, and this is not about Mr. Hernandez. This is the hypothetical. The state calls a witness. There is only one witness. You believe the witness. You find the witness to be credible. That witness proves the state's case beyond a reasonable doubt. So the first thing is you have to find the witness credible. Does everyone understand the hypothetical? So you find the one witness credible. That witness has proved the state's case beyond a reasonable doubt. Let that marinate in the mind. Is there anyone here who says, I still will not find someone guilty, even though I believe that one witness is credible and that one witness has proven the state's case beyond a reasonable doubt? That's the hypothetical. That's the question.
Okay, now I have to, you can take my number off.
Take your number off.
Sorry.
Okay, so hearing judge's explanation, who still believes the same thing? They would still need- Can I put a question?
You gotta stand up at the mic.
In my head, the hypothetical situation that popped in was a witness proves it beyond reasonable doubt, and then evidence gets put up that adds doubt in my mind after the testimony. Would that still be like a situation that could happen? Or would the witness be at like the very end, proving beyond reasonable doubt, nothing else added?
Right, so that's changing the hypothetical. And in this hypothetical,
There's nothing
there's
after.
nothing else being added. You just believe the witness.
Okay, yeah.
A million things can happen. We can go down so many different roads. That's why I'm
I'd like to
trying-
remove mine then.
Okay,
yes.
so we're just keeping it simple here, at the very basic explanation of the one witness. No extra hypotheticals. After the judge's explanation, does anybody still feel like they could not follow the law, and they would require more?
Sure.
Chair number 23, you still feel the same?
Wait, so I was trying, I'm gonna the original list. Are they taking back?
I can't hear her or see her.
All right, everyone, I'm going to need everyone to make sure you either speak loudly or step up to the microphone. Brenna is taking everything down. She's the court reporter. If she doesn't take it down, then it did not happen. Juror number 23.
I was just trying to put my name on the original list, I guess. I'm not really understanding the question, if I'm being completely honest.
Would you want more?
Yeah, I would want more, yeah.
We can play back, sure, thank you. Okay. Has anybody here ever been convicted of a felony, been accused or convicted of theft? And, or know somebody who has been? If it's something that you don't want to talk about out loud, in front of everyone, we're happy to call you back and talk about it. It's important to know. So if you know somebody who has been accused or convicted of theft, and you feel like, yeah, just leave it there. Can you please raise your placard?
You're just asking if we known someone?
If you or a close friend or relative has been convicted of theft, how about we do it like that? You, a close friend or relative, has been convicted of theft. Your number 2, is something you're comfortable talking about?
Ex-girlfriend. Back when I was younger, she stole money out of a register for Walmart. She got caught, she got charged, she was found guilty and didn't have to pay restitution too much for the service. But other than that, I think it was fair.
Are you gonna be able to be fair in this case, even though you?
Yeah, absolutely.
Okay. Who else had raised their card?
I did, but I don't want to talk about it.
Okay, chair number 42. Chair number 14.
20 years ago, misdemeanor, $50 less. Somebody took something from me, I took it back, I got caught.
Okay. All right, thank you, chair number 14. Chair number 35.
Does it count if it was someone that worked for you?
Do they have permission?
No, but it wasn't really a friend, but it was an employee.
Oh, I see what you're saying. I see. It only matters to me at this point, is it going to affect you being fair and partial?
Now,
Okay, thank you. Is there anybody here who would not be able to sit in judgment of another because of cultural, religious, or personal beliefs? Chair number 44. Okay. And would you like to explain in front of the mic?
Humbly, I don't feel comfortable in the conviction or judgment of others because I am just as guilty in every way. Now, go ahead.
I was just gonna say thank you.
Okay, thank
For
you.
letting us know. Anybody else feel like they could not sit in judgment of another personal, religious, moral, cultural? Chair number 24.
I was wondering, are you asking the question about have you been a victim of theft? Is that part of the previous question?
I can, I was moving along.
Oh.
I've been taking a long time. But I can. Chair number 48.
I don't want to talk about it.
Okay. All right. Has anyone here been a victim of theft? A lot. Okay. I'm sorry. I'm running out of time. Anybody, so of those people that raised their flag on a serious note, anybody who has been a victim, unfortunate. Do any of you feel like because of your experience as a victim, you would be unable to be fair and impartial in this case? Tier number 5. Tier number 10. Tier number 29. 27. 7. 24. 37. 48. 38. 52. 66. 80. 69. And your card's been. Thank you, 77. All right, thank you. Okay. And is everybody here read, speak, and write? Okay, anybody having trouble? I guess look around. Do you feel like you noticed anybody that doesn't seem to be following well? I've had some issues where we do this in panel and we realized somebody could not speak and understand English very well. Okay. Does anybody have any questions for me they feel like I should know that would be important to your ability to serve as a juror on this case? Anybody leaving the country today? Has it told the court already? All right. Your number 18, 29709.
Actually, I had a question on that because the judge mentioned about leaving the state. If we did have something planned over the weekend, how would that work as far as time constraints?
I believe we'll call you back up and ask you.
Okay,
that. So
awesome.
mark you down. Your number 18. All right. Thank you.
All right, defense.
Yes. Okay, all right. Hi, my name is Ron Zimmerman. I am the defense counsel for Michael Hernandez. Michael has waited over 2 years for this day. He's waited quite a while. He wants his day in court, and he deserves it. He is 54 years old, works as a landscape engineer, so he does landscaping. And he graduated from St. Gerard's High School here in San Antonio. Has anyone here graduated or attended St. Gerard's High School? Can't see anybody on this side. Usually we're doing this in a close confined situation in the courtroom, not all spread out. So it's difficult for us attorneys. Okay, the prosecutors, he asked you all about whether you could render a fair judgment on someone who had been previously convicted of theft, and would it affect your judgment on whether, in the current case, that a theft actually occurred? Could you all just raise your signs up or your cards up? Number 10. Number 5. Okay, number 5. Why would that make it difficult for you? No, go ahead and stand up. Yes. Go to the microphone.
All right, and you, I'm sorry, but you're gonna have to keep your mask up.
It would, because I would keep thinking about what happened in the past would affect my decision now.
Okay, so you couldn't put that aside?
No.
Okay, all right. Anyone else that cannot put that aside and look at the day in question all by itself without making a judgment as to whether that is in conformity with something else that happened prior? Number 4. Same as that, okay? How about over on this side? Number 1. Okay, number 7. Number 24. I know we did this laboriously before, but I want to make sure that we're completely clear on this. Number 3. Number 27, number 38, number 41, number 45. If my glasses are working correctly. 46, 47, 48, 37, 26, 52, 80, 69, 78. Did I miss anybody? 72 and 66. Okay. Okay, the state talked about the elements of this situation. They said that the state has to prove that there was intent. Does anyone have any confusion about intent and what that means? So this actually happened to me a while back, not to me, but to a friend of mine. And he was relaying to me what happened to him. So hypothetically, he was in the HEB with his kids. And you know how it goes. How many of y'all have children? And when you walk, particularly young children, when you walk into the HEB, the kids want everything, particularly on the candy aisle. You avoid the candy aisle. And so my friend was doing that. He was in the store and he only came in for a couple of things. But as he was going through the store, the kid said, I want this, I want that. And he told me that being a soft-hearted guy, he kept picking up the things that the kids wanted. And pretty soon he had a handful, an armful of items, and he went to go pick up one other item, but his arms were too full. So he put down a couple items and he put one of the items in his pant pocket, fully intending to pay for it when he went to the cash register, fully intending to. But in the rush and the hustle and bustle with the kids and dealing with the kids, he actually forgot to do that. Went through the line, but forgot to pay for the item and went out to the car. And he told me that As he was reaching in his pocket for his fob to unlock the car, that's when he found the item. Who thinks that that man was guilty of theft? Number 10. Yeah. Number 2. Number 8. Number 18. 45. 43. 27. 62. 73. Wow. 7. 14. 16. 24. 34. 33. 46. 58. Did I miss anybody? 69, 78, 80. Okay, number 24. Did you have a question?
Well, I think in this situation, that my issue is, I don't believe that guy. You know what I mean? If you're saying he isn't lying, then it isn't that, in my opinion.
Okay.
There's no way I believe that guy forgot that day. You know what I mean?
Okay. Will it change your mind to know that he told me that he went back into the HEB and paid for
That will change my mind.
it? Okay. So he did not have the intent to permanently deprive HEB of their property. When he walked out the store, he did not have the intent to do so. And that is what you're going to be asked to be judging, is intent. That's part of this crime, is that state must prove beyond a reasonable doubt that there was intent to permanently deprive someone of their property. Okay. Okay, this is unusual. I'm not used to doing this. I've been doing this for quite a few years, but first time I've ever had to hold up a microphone when I'm talking to a potential juror, so you'll have to forgive me. The prosecutor went through the evidence pyramid. The first step is no evidence. So there's absolutely no evidence, no trace of evidence whatsoever. The second is what's called scintilla of evidence. Any evidence at all, even the smallest reasonable amount of evidence. The third step, and this is all prior to going to court, this is all out in the field, so to speak, is reasonable suspicion. And that should be based on specific or particular facts or reasons, not based on a hunch or guess. And the third, or excuse me, the fourth, is probable cause. That means it's reasonable and trustworthy information that a particular person has committed a particular offense. Trial court evidence is preponderance of the evidence, the greater weight or amount of evidence. Then the next step is clear and convincing evidence, a firm belief that the allegations are true. And the last step is what the state already talked about, and that is reasonable doubt. And that means it has to be beyond a reasonable doubt. Does anyone think the standard of proof, reasonable doubt, is too high? Is that too high? You all agree with that as being the ultimate standard of proof in a criminal trial? See, just because the police officer makes an arrest, he's not required to judge whether something is beyond a reasonable doubt. All he has to do is make a judgment. Does it doesn't reach the standard of probable cause. And that doesn't even get him into the courtroom, that just gets him from the field to make an arrest. But jurors are required to determine beyond a reasonable doubt. So it's a much higher standard. Just because someone's been arrested doesn't mean they're guilty. All it means is that there was all it means is that there was reasonable cause or probable cause. Okay, does that bother anyone that you have to, that just because someone's been arrested, it doesn't mean that that they're guilty of that crime? The state went over. Yes. Oh, I'm sorry. Thank you.
I just have a question.
We're gonna need you to go to the microphone.
Judge.
Please go to the microphone.
Didn't the judge say that reasonable is not clearly defined any longer?
That's correct.
Okay.
Yes. Reasonable, beyond reasonable doubt is not defined under our laws.
Okay.
But probable cause is, everything is prior to that, but the highest standard is basically common sense. The state, the prosecutor asked you about Fifth Amendment. Who would want to see Michael testify on his behalf? Do you think that that would be, whoops, number 24?
I'm sorry, what was your question, sir?
Who would want to see Michael testify in this cause? 24, 47, 34, 33. Wow. Okay. 48, 47. 12. Oh, yeah, you're just holding. Okay. 29, 41, 52, 71, 60, 59, 72, 74, 64, 43, 66. You want to understand that, as the judge explained prior, he doesn't have to testify. He does not, we do not have the burden of proof. The state does. They made the accusation, they have to prove it. And he doesn't have to do anything. It's their responsibility. Number 52, you have a question?
Yes, are you?
Microphone.
Thought I was speaking loudly.
When you asked, would we want him to testify, or are you asking us, would we require him to testify? Want to require him to testify?
Well, want is just a desire, but
Right.
require means that
You'd have to.
that he has to. Would you consider that a requirement for you to make a fair judgment?
No, not a requirement.
Okay, but you would want it.
Yes.
Okay. Number 41.
Basically the same thing he said. Require it, no, and it wouldn't probably impact my verdict if I see other evidence that suggests that he's guilty or not guilty. But putting myself in the shoes of the defendant, I would say, I would speak for myself if I thought that I was not guilty. So I would want to hear what the defendant had to say, but I would not require it from the defendant.
Okay, thank you. How strongly would you feel, is hypothetical, about the following statement? If I were accused and innocent, I would testify in my own defense. 41. Okay. Sure. If I were accused and innocent, I would testify in my own defense. Well, that's a lot of numbers. Okay. Okay, is there anyone that has a question that is unanswered so far? Well, I would like to thank you all for coming in. I know it's a hardship, but it is one of the requirements of our democracy, of our society. And actually, it is one of the highest callings of our democracy to sit on a jury. This is where the rubber meets the road. And if you have to ask yourself a question, if this happened to you, would you want to be able to have, would you want to have a jury render a fair and impartial verdict? Okay, if there aren't any other questions, then thank you very much. And I will turn it back over to the judge.
All right, thank you. Ladies and gentlemen, what's going to happen now is I'm going to have you wait outside, and then we're going to call you all back in, and we will let you know who's going to be on the jury. So if everyone could please rise for the jurors, and I'm going to need everyone to go outside.
Excuse me, I guess, Judge, I do have one question. They kept telling me that someone was gonna give me an idea how
No,
long the
This is the
trial.
thing. If everyone will step outside, we'll take that matter up. Some of you may be called back in,
Oh,
but we'll take it up at that time. Thank you. All right, are you juror number one?
Yes, ma'am.
All right, the state and the defense may have a question for you. State.
Thank you, Judge. Ms. Christensen?
Yes, sir.
Okay, just have a quick question to follow up. You were explaining the nature of this particular charge that enhanced noted that to get to this type of offense, you have to also allege there were two prior incidents, two prior convictions. And the law requires the juror to be impartial. Deciding, looking at the evidence and deciding whether or not cases proven beyond a doubt, offense happened. They specify. So, would you be impartial in reviewing the evidence, charge of theft of this incident without letting prior allegation influence your decision?
I don't think I could.
You don't think you'd be able to set those two priors aside and just analyze this particular instance?
If I'm being honest, I don't. I'm sorry.
Okay.
No question.
All right. Any motions? Is it agreed?
I'll agree. I'll agree.
All right, thank you.
Thank
Your
you.
excuse.
I assume Ron, you would want to-
That would be a positive assumption.
Okay.
All right, are you juror number three? Hello. The state and defense may have a question for you, state.
Hi, Ms. Silva.
Hi.
Ms. Silva?
Yes.
Okay, so the charge of theft enhanced, as we mentioned, we are also alleging that on two prior instances, two persons have been convicted. But the law requires a juror to assess this instance separately from that. So it's an element, but just because those exist, that's not something that you can necessarily consider trying to decide whether or not it happened this time. Will you be able to follow the law and assess whether or not that happened this time? Or will you consider that there are priors and let that affect your decision?
Well, that's a good question. No, I think I can let my judgment go of the last two and just focus on this case, depending on what the evidence is. Does that make sense?
Yeah. So you believe that you can listen to the evidence and decide whether or not it happened this time?
Yes.
Defense?
Ms. Silva, are you saying that you believe that because you've heard that Michael was convicted of two prior thefts, that will not influence your decision as to whether he's guilty or not guilty? His guilt or not on a question which is past, which is beyond the first two?
Yes.
Say again?
Yes.
So you can make it independent,
Yes.
okay? All right, so you won't allow the other two priors to influence your decision?
No, it's gonna affect my decision.
What's that?
It's gonna affect my decision.
It will
Yes.
affect your decision?
Yes, it will affect my decision.
Okay, all right, thank you.
You're welcome.
State, any further questions?
No additional questions, sir.
All right, any motions from either side?
Stay with agreement.
All right, thank you.
Thank you.
I didn't hear that. What was that?
I'll agree.
You'll agree?
I'll agree.
All right, and if both parties just can remember that these are hypotheticals, we're not asking specific questions about, no problem. All right, and what is your juror number, please?
4.
All right, juror number 4, the state may have some questions for you. State?
Thank you, Judge. Hello, is this Mia?
Yes.
Hi, Ms. Mia. We were talking about the charge of theft enhanced. And part of that charge requires the state to allege that there are two prior theft. As a juror, you'll be required to, before you can return a verdict, find beyond a reasonable doubt that this offense, this particular offense occurred independently of the prior convictions. So we have to prove to you that there are prior convictions, but also beyond a reasonable doubt that this offense happened. Would you as a juror be able to analyze this offense without letting the priors affect your decision?
No, sir, because I think if he was already, because the two prior claims already that were done, and if he failed to do another one, then I think he should know better from right and wrong.
Okay, I understand. And now I'll reiterate that it's an accusation. So from the outset, all hypothetical, we are alleging against two prior convictions. So if you hear evidence that there are two prior convictions, could you set that aside in deciding whether or not this instant offense happened?
No, sir, because I think that if you really did two wrongs, there's not, I don't agree that he should have been able to get away with something else that he did again, because it's just like a, how can I say this? He did it again, just, I think it's in his, I'm sorry, I'm getting confused here.
I understand what you're saying.
But yeah, I don't think it's fair to,
Okay, thank you.
All right, defense. All right, any motions?
Thank you.
Yes. All right, you may excuse.
Motion for an agreed strike.
State, are you in agreement?
I'll agree to strike.
All right, then that will be granted. All right, next juror, please. Oh, no, it's not. Yeah, no, it will not be long. Hi, what is your juror number?
Number 7.
All right, state.
Thank you, Judge. Hello, juror number 7.
Hello.
We were talking about a lot, but the charge is that. So we as the state have the burden, we have to prove that there are two prior convictions, but also that there's a theft that happened on the instant. And as a juror, you'd be required to assess whether or not this theft happened, without letting the priors affect your decision on this instant case. Would you as a juror be able to analyze and make a decision on this instant case, set aside whether or not there are two prior convictions?
I'll be honest with you, I will, in the back of my head, I would still be thinking about the prior, the other, if it's conviction or accused of what happened prior to that.
So even though they're just accusations at this point, you believe that you would have a tough time as a juror separating the instant allegation from two prior allegations?
Yes, sir.
Just to reiterate, you would allow that information that you heard about the prior convictions to affect how you think about the current case.
Yes, sir.
All right, thank you.
Thank you.
Any motions?
Motion, defense motion for agreed strike.
State, are you in agreement with the strike or no?
Judge,
That was number 7.
Yes. Yes.
I'm gonna look at it. My chief looks on my face. You can just ask, strike for cause.
Yeah.
Just ask to strike for cause. Otherwise,
Yeah, I'll use
Mhm.
strike.
All right, you guys are on live. All right, juror number
24.
24.
Yep.
Was there any questions that were being asked of juror number 24?
I don't believe so, Judge. Thank you for coming in.
All right.
Am I selected?
No, just wait and we'll call you
But
back with the
This was the
panel.
time I could ask questions, right?
Yeah, we'll call you back with the rest of the panel, okay?
Oh, so I can't ask questions now.
Yeah, we'll call you back with the rest of the panel. Yes. No problem. All All right, what is your juror number? What's your juror number?
I'm sorry,
Your juror number.
26.
All right, state or defense may have questions for you, state.
Yes.
Hi.
Hi.
So the charge of theft against
I can't hear you.
Right. So theft enhanced, this charge requires the state to present evidence.
Right.
That there are 2 prior convictions, as well as there being a theft on this particular day.
Okay.
You as a juror would be tasked, required to find beyond a reasonable doubt that this theft happened without letting prior convictions affect that decision. Would you be able to do that?
I don't think so.
You feel like knowing that, well, if we present evidence that there are 2 priors, would that influence your decision? You feel like that would bias your decision?
Yes, I do.
Yeah, so that would affect you and you should not put that out.
No, sir, I don't think so, because if he's already done it twice and he's being accused of it again, in my mind, he's still guilty.
All right, excuse me, juror number 26.
Yes.
These are all hypothetical questions. These are not questions about Mr. Hernandez. Do you understand?
I do understand that. Yes,
All
ma'am.
right. Defense, any other questions?
No other questions.
All right, if you'll wait outside for us, please. Any motions from the defense?
Yes, motion 403.
No, are you asking that the juror be stricken
Yes.
for cause? All right, state, any response? All right, then number 26 is stricken for cause. All right, what is your juror number?
27.
All right, the state or defense may have some questions for you.
Okay.
How do you pronounce your last name?
It's Marin.
Adi?
Yes.
So the allegation here is that, just to try to explain, we would be alleging that an individual committed theft on this particular date,
Mhm.
but before this date, has also been convicted twice.
Mhm.
So as a juror, you'd be tasked with deciding independently whether this happened without letting 2 priors influence that decision.
Mhm.
Would you be able to set those aside and be impartial in looking at whether it happened on this?
Honestly, no, because I do work retail and I do see theft a lot, like on a daily basis. So no, I probably wouldn't be able to not look at the other 2 cases or judgments or whatever.
Thank you, Your Honor.
All right, thank you.
Motion for strike, to strike.
State. All right, that will be granted. All right, what is your juror number?
29.
All right, state or defense may have some questions for you.
Sure.
The general board dies, and this is only better about
Mhm. Hi.
You had mentioned that you, for one reason or another, may have a difficult time being fair and impartial.
Yeah, we had the storm, a snowstorm, and we had a leak in my house. So after setting everything up, we had workers, we had a company come and take care of everything. They were gonna lay the floors. And they did it not too long ago. So I usually have my wedding ring and band together. But they had to go to my main bathroom where I have my jewelry box. So one of the person, I checked, like last week, I checked, I don't usually put it, but it only had the wedding band. So I called the boss, I called the person in charge of the project, and he spoke with the person that hired the workers and the worker,
I guess, I'll stop you there.
oh,
It sounds like you're a victim.
yes, I am. Oh, sorry, I thought that you wanted to know the details on it.
No, it's fine. It sounds
Yeah.
like it's recent, so maybe an.
It is very
active
recent,
case.
yeah.
So we won't get.
Sorry, I was gonna tell you the whole
We
thing.
won't get
but-
too into it.
Okay,
But it sounds like you're a victim of that.
yes,
And would you be able to set your experience aside as a victim and be impartial?
I don't think I could, especially if it's too recent. I don't think I could. It would be unfair for me. Mhm.
Well, that's. Mr. Zimmerman can make
Oh,
this.
you have questions too?
No questions.
Okay, thank you.
All right, thank you.
Motion for, to strike.
Any objections? All right, if you can bring the next juror in, please.
And that was 29.
Yes. All right, what is your juror number?
I'm sorry.
Your juror number?
Oh, 37, ma'am.
All right, the state or the defense may have some questions for you, state.
Sure.
Thank you, Judge. Hi.
Hi.
We had talked about this charge theft enhanced. Requires us to, some evidence that showed that there's a theft that happened on this date, but that there are also 2 prior convictions. And you as a juror would be tasked with deciding whether or not we prove that happened in this case.
Right.
Not letting the 2 priors affect that decision. Would you be able to do that?
No. And the reason, I mean, I have trust issues. So it has to, like, I would have to see more evidence. I would have that in the back of my mind, like, he's done it before. I felt like it's been done again. So.
Any questions, defense?
So you don't think that being in the back of your mind, that you could disregard what's in the back of your mind and not allow it to influence your decision as to hypothetically whether somebody did something on this day, even though they've been convicted twice before?
Again, I have
That would
trust
affect-
issues. It's happened before. It's most likely going to happen again. And it would, yeah. I would be thinking about what there was a previous
So
instance.
you could not make an independent judgment as to what happened here if you knew about here and here.
Correct.
Okay.
Thank you.
Welcome.
You can step outside, please. Any motions?
Motion to strike. What number was that? 31.
All right, everyone, just one moment. Can we hold off for the next juror, please? Can I see the state and the defense in the back for a moment?
really enjoyed the brief respite of the past.
Yeah.
Man, I think I'll pause up my class.
Oh, me too. Yeah. All right, juror number 18.
Yes.
State or defense may have a few questions for you.
Okay.
State?
Hello, Mr. Gutierrez.
Yes, sir.
Hi, you had mentioned something about having time frame conflict in your schedule.
Yeah, we had a planned vacation starting Saturday, going through Wednesday of next week.
Oh, okay.
I didn't know how, I didn't mention something when the judge mentioned, because she mentioned out of state. We were staying in state, but we're going to the coast, but we have everything all scheduled and paid for.
When do you leave?
It would be Saturday morning, and we would come back Wednesday evening.
So if this case were to go into next week, there would be a time conflict.
Yes, because I guess it would just be Monday through Friday that the case would go, right? So yeah, that Monday probably would be, yeah. Yeah, so probably if it were to go past Friday, yeah, it would conflict on that Monday, Tuesday, whatever.
Do you have any conflicts tomorrow?
For tomorrow, no. My only concern with tomorrow, my wife just had surgery on Tuesday. We had that planned. I was able to help her out yesterday since I was virtual. Today, she's just home with my daughter. She's 14. During recovery, that's the only concern I would have with tomorrow. Thank you, sir.
Just one second. Any questions from the defense?
I'm sorry.
All right, thank you.
Thank you.
Disagree on that one. I don't-
How late do you want to do it?
Huh?
How late do you want to do it?
Oh, we can discuss that. All right, juror number 47. Hello. The state or the defense may have a couple of questions for you. State?
Okay. And I'm sorry, I didn't pronounce your last name.
Santama Tomichan Chetupura.
Did I say Thompson?
Yeah.
Okay,
Tomichan.
that works.
Yeah.
You had mentioned during the court diary, there was some conflict.
Yes.
Could you please explain?
Yeah, actually, we have planned to drive to Smoky Mountain for the next week. You know, we are starting from Saturday early morning. And I have a doctor's appointment tomorrow, 11 o'clock, for my thyroid.
And where were you driving to?
Smoky Mountain,
Smoky Mountain?
Tennessee. Yeah.
Oh, okay.
Yeah.
That's all. Bye.
All right, any questions from the defense?
Yeah, I can only hear about half of that. I'm sorry. You're going to be receiving treatment, is that what you said? In the Smoky
No, no.
Mountains?
No.
I didn't hear
No, sorry. See, Friday, 11 o'clock, I have a thyroid ultrasound. Okay. And Saturday, we have booked for Smoky Mountain trip. Our family, 3 of us are driving to Smoky Mountain.
Okay.
From Saturday onwards, 1 week I have taken leave from my work. Is that clear?
Yes. All right, thank you.
Okay. Then.
Yes.
And
All
there's
right.
also the 33.
All right, just one second. Defense, any objections to juror number 47? Do you want to keep her on the panel? All right. Okay. All right, juror number 52?
Yes.
Yes, state or defense may have questions for you.
Sure.
State?
Thank you, guys. That's fine.
So far, so good.
So during the general report diary, you mentioned something about this case charge. You have a good full-time, partial.
It depends on, because that was the question with, when you're talking about theft, like, would it trigger bias? And that's the thing, I'm just not sure. And that's kind of where the question of bias comes in, is like, I'm not entirely sure if it would or not. I've been the victim of theft a bit. And it's just one of those things I don't know. It's one of those things you don't know what you don't know. if that makes sense.
I hear what you're saying. Unfortunately, we do.
Right, and that's where I'm. Trying to think of how to. I guess it would just be situational, depending on the exact situation, and that's kind of my description of that. Is just, you're asking me, would I have bias? And it's almost, I don't know if I'd have bias.
Really, hypothetically. They prove it's great architects. And so you're now looking to decide whether or not the state proves it's gonna be without.
So they've proven there's two priors.
Let's say that in your mind, they've proven that to you, and now you're just looking whether or not we've proven to you beyond a reasonable doubt that this time.
Are the priors the same situation?
It would be just that. Just hypothetical, just that.
Then in that case, the two priors wouldn't make it. It would, if you're showing a pattern of a certain incident that's being repeated, not just general theft, but like a very specific thing, then like same place, same like item, and you're trying to show a pattern, then okay, I could say, okay, those two priors are showing proof of a pattern. But if that's not the case, and it's just two instances of theft, and I'm supposed to use that for this third instance, that I don't know. I don't think that would create a pattern for me to use those previous two.
So this hypothetical, there's just, you've been proven that two thefts have occurred. Leave it at that.
Okay.
You're trying to decide impartially whether we prove it to you that it happened this time. You be able to do that impartially.
Yes.
Defense.
Yes, sir. You're saying that correct me if I'm wrong, that if the manner and means were the same on the prior two thefts, then that would affect your judgment on the third accusation, even though it has proof, but that would influence your decision.
I think if they're showing a pattern of behavior, specifically, even like say, hypothetically, say stole something from this one store, and then same type of something got stolen from that store like 2 months later, and then now third time, same thing got stolen from that, showing that pattern. If that's something that's being, then yes, I think that would influence.
Manner and means is important to you, i.e. that if it was hypothetically, if there was a car theft, a identification theft, and then a retail theft, that affect you? If prior two cases were completely different, although that person was completely different type of theft than the one that you're going to be asked to assess.
Okay, well, if the two prior were really different, but they were proven to have happened, then it's, if they were drastically different and the third one's drastically different, that'd probably still be the case. Now, if they were like, say the first two that were proven were one type of theft and the third was different, then yeah, I wouldn't consider those, if that makes sense.
All right, thank you.
Thank you.
Any motions from the defense or the state?
A motion for it to strike. A motion to strike cause in that he said that if the manner and means were the same, which in this case they are, that it would bias.
Oh, we're dealing with hypotheticals here. Yes.
The state objects, he could separate the two priors and just assess the current incident, unless there was a shown repeated pattern. But my understanding, we're doing hypotheticals here. I don't anticipate Mr. Zimmerman allowing.
Mr. Zimmerman,
Yes.
here's a mask.
Similar incidents of that kind. Aside from convictions.
All right, and what was the juror number, please?
That was 52, wasn't it?
All right, 52 is defense strike for cause will be granted. All right, is there anything else from either side? Any more jurors that need to be brought in? All right, the last juror that will be brought in is juror number 33. Juror number 33, if you approach the microphone, it's the court's understanding that there was some sort of time constraint.
Yes, next Wednesday, I have an appointment that can't be canceled or rescheduled. I was just wondering if that would be an issue.
All right, and so that's for Wednesday. So you would be available Friday, Monday, and Tuesday, just not Wednesday, is that correct? All right, thank you. All right, so I'm going to allow the defense and the state to do their strikes, just so the record can be clear. These are the jurors that were agreed to, and these are the jurors that were stricken for cause. Number 1, agreed. Number 3, agreed. Number 4, agreed. Number 5, agreed. Number 7, agreed. Number 10, agreed. Number 24, agreed. Number 26, cause. 27, cause. 29, cause. 37, cause. 38, agreed. 41, agreed. 44, agreed. 46, agreed. 48, agreed. 52, cause. 65, agreed. 66, agreed. 69, agreed. 80, agreed. Is that what everyone has, state?
Yes, sir.
Defense. All right, everyone, I'm going to take a short break.
I am a visitor. Filling in yourself.
All right, everyone, please be seated. All right, ladies and gentlemen, of the jury, thank you for your service. We can't have jury trials without jurors. When I call your name, that means that you are going to be on the jury in the 187 District Court. Deputy Laura will take you where you need to be to show you where you need to be tomorrow. She is right on the side of the wall. So does everyone see Deputy Laura? The 187 District Court is on the 4th floor of this building. She will take you there and let you know where you need to report. To everyone else, you'll see that there are pieces of paper that are in your chair. That is notice that you served your jury duty today. These are the jurors that will be on the jury. Tiffany Walker, Rebecca Prinsmeyer, Rashida Irving, Salong Supra, Jose Gutierrez, Carlos Segura, Michael Howdyshell, Foster Rivera, Jess Torres, Nora Aguirre, Thomas Zidell, Joyce Palmer, the Hector Benavides, Mason Charles. Everyone else, again, thank you for your service. Slowly move, don't rush. And you may leave. But all of the other people, please remain seated.
I'm sorry. At least you get to not go to work for a couple of days.
Yes. All right, so the people who should still be here are, you were originally assigned as jurors number 6, 8, 15, 16, 18, 19, 20, 22, 25, 30, 32, 36, 49, and 53. I don't expect that any of this trial will be in the news, on television, on Facebook, or any other media post. But if it is, you are to avoid it. The only evidence you are to consider, I'm sorry, quiet in the back of the room, please. The only evidence that you are to consider in this case is evidence that is presented in the courtroom. Does everyone understand? All right. So what's going to happen is Deputy Laura will show you where the 187 District Court. We're going to start tomorrow at 10:30. It may be important for you or easier for you if you get here a little earlier. Parking downtown is atrocious at best. And what you can imagine is there are jurors who come in here on a daily basis. All of the people who work in this building are looking for parking downstairs. I'm sorry, parking downtown. people who work in surrounding areas are looking for parking downtown. So if you're here a little bit earlier, it may be easier for you to get parking space. There's parking available at the parking garage. There are also some parking at the parking meters. So with that being said, tomorrow when you come in, I'm going to swear you in tomorrow at that time for this specific case. Does anyone have any questions? All right, we're going to rise for you, and Deputy Laura will show you where you need to go. Yes, just leave your numbers in the chair, please. All right, Eric can be seated. Mr. Hernandez, you'll need to be in court tomorrow on time. I would suggest, court's going to start at 10:30, but I suggest you get there earlier than 10:30, okay? All right, if there is nothing else, I'm going to close the record on this case. I'm going to stop live streaming and head back upstairs to our courtroom.